Honorable Chair.
Yes, sir.
I do propose, I was using the raising of hand electronically. I've realized that you don't consider that.
I do, but now and then I miss it. But Janchi proposes. Who seconds?
I was not in attendance. That is why I'm not seconding acting speaker.
Those people who were at the meeting, could you speak, please?
I second, Honorable Acting Speaker.
Dr. Magwanisha, thank you very much for hearing your voice. I haven't heard it for ages. It's good that you speak, even if to second an important motion. That this is a true record of the previous minutes. Thank you very much. Let's move to matters arising.
Deputy Speaker.
Yes, sir.
There was one item on the agenda on the day. It was,
yes.
The composition of the Section 194 committee.
Okay.
That decision has since been implemented.
Yes.
And that committee now consists of all parties that wish to participate.
Yeah.
36 members, but the ATM opted not to participate.
Okay.
But provision has been made for that committee for that party to participate.
Okay. Is there any other matter arising? None. Let's go to the next item on the agenda. The report on the delayed replies to questions. I assume this is the subcommittee work. Let's get a report on that.
Request staff to please display the items. The next item, may I proceed, Deputy Speaker?
Go ahead, Ndati. I was waiting for you.
Oh, my apologies.
I was waiting. No, it's okay.
Deputy Speaker, honorable members, this report is about delayed replies to parliamentary questions. In terms of the questions procedure, ministers have to respond to questions within 10 working days. In the event that they are not able to meet that timeline, they can apply for extension for another 10 working days to respond to questions. So this report seeks to give an analysis of what has happened, or just the highlights of what has happened in the last quarter before we adjourned for the June recess. The Speaker wrote to all the ministers who owed Parliament replies, and she wrote to 24 ministers. And in essence, the Speaker was asking them to give reasons why they had not replied within the times given. Because in some respects, in fact, in many respects, certain ministers did not even ask for the extension of the additional 10 days. So she wrote to 24 ministers. Out of the, and these are the number of replies that were outstanding on paragraph 3. And I won't go into details because the figures are there. Out of the 25 ministers that were written to, responses were received from the following ministers. Minister Kubai, Minister Sisulu, former Minister Mapisa Ngabula, Minister Kubai in her capacity as Acting Minister of Health, and Minister Didiza. And they gave various reasons why they could not respond timeously to the questions addressed to them. And we have given these reasons in the report. The rest of the ministers did not reply to the Speaker. The ministers that replied also expressed regret for the delay in submitting replies to Parliament. And they committed to put measures in place to ensure that they adhere to the requirements of the rules and, importantly, to their constitutional responsibility of accounting to Parliament for the areas under their control. The current status of the replies is as given in this report. I think what is important to indicate here is that most ministers have since replied to the questions that were addressed to them, even though they did not give reasons why there were delays. I also need to indicate that the reply that was outstanding from the President or the Office of the President has since been submitted. And this is the status of the replies to questions as matters stand at the moment. I don't know, say, if you wish me to go through it, but the report seems to be clear. And we thought we should give this report because, among other things, this meeting today will discuss a mechanism for monitoring replies to questions, members' questions. And so, with your permission, I would like to stop at that point for now.
Okay, thank you very much. I suggest that given the picture that we are seeing, and presumably all members have this report, that we must look at the proposal that is being put forth in order to deal with this problem, so that it doesn't reoccur, and if it does, what steps we take. I would suggest that we move to that next item, which makes proposals for that. Can we go ahead and do that? Can you flight that part? The mechanism for monitoring of replies and questions. You've given us the current status quo and previously what was done by the Speaker and the responses. And so now we are dealing with a proposed mechanism for handling this, for monitoring replies to questions. Who speaks to this item?
It should be the chair of the subcommittee.
The chair of the subcommittee is Honorable Deputy Chief Whip, Doris Lakude. Please go ahead and talk to us.
Thank you very much, Honorable
I'm wondering how the technical team can help with the sound. It's pretty bad. We can't hear you.
she must just stand in one place.
Okay. Deputy Chief Whip, take the advice of your Chief Whip. It might work. Honorable members, this is a dramatic example of the poverty of network because it disrupts. The ministers responsible for infrastructure must do that. Who can speak on her behalf in the meantime? Dadit Kaso, can you handle that?
Certainly, sir, if that is...
Please go ahead. I suggest you do that. The Deputy Chief Whip will understand because her reception is pretty bad. Let's proceed. She might be able to join us in responding to questions that arise here. Go ahead.
The Rules Committee on 9th of March 2021 discussed the implementation of National Assembly Rules 136, Rule 136, specifically where the rule says that the Speaker must develop a mechanism to monitor questions to the executive as endorsed as unanswered. And it was agreed that the subcommittee should look into the matter. And Speaker did indicate that in the meantime, she would continue to exercise the powers given to her by the House to ensure compliance with the rules of the House. Hence, the report I gave earlier of the Speaker writing to the executive. The subcommittee deliberated on the 6th of August on the matter. Now, in terms of what the rule says, it says that the Speaker must, in consultation with the Rules Committee, establish a mechanism to monitor and report regularly to the House on questions that have been endorsed as unanswered on the question paper. 2, the leader of government business must be informed of any steps taken in respect of any member of the executive in giving effect to monitoring of replies to questions. Now, in the previous parliament, the 5th parliament, the Rules Committee had agreed a mechanism, and that mechanism entailed the establishment of a subcommittee to monitor and report on questions endorsed as unanswered. And it was a multi-party committee. The Rules Committee agreed to that. It reported to the House. The item remained under further business until the 5th parliament ended, and therefore it was never implemented. So when we met beginning of the year, the sense was that maybe we should avoid establishing structures while there are offices that can exercise certain functions. And hence the Speaker then said, look, she will continue to perform the function until given guidance by the Rules Committee. Move on, please. The subcommittee concurred that the questions mechanism is a very important mechanism, and it's a mechanism that should continue to be strengthened by Parliament. And that it had also endorsed a long-standing convention that as long as such, while the Speaker is unable to lay down the form in which a minister should reply to a question, a minister is expected to confine him or herself to the points contained in the question concerning matters under their control. In other words, the points that are raised by members ought to be responded to, whether in writing or orally in the House. At least there must be a response. There is, of course, acceptance of the fact that the presiding officer cannot dictate how the quality of a question, of the response by a minister, but at least the minister must give a response to a question and give that response fully. Now, the Speaker had also, in the meantime, put together a process to be followed. And this is what paragraph 2 deals with. The process by the Speaker was that she would write to the ministers first, and number 2, she would also write to the leader of government business to say, give reasons, and not to the leader of government, but to ministers, and indicate to the leader of government business that she has written to ministers for them to give reasons. And 2, if ministers continued not to comply with the rules, then there will be a reprimand in the House by the Speaker. And the next step will then be a complaint to the President. That was what the Speaker submitted for consideration by the members of the subcommittee. Okay, move on to 3, please. Here it basically says that members affirmed the need for measures to monitor these replies. And members noted the need to strengthen liaison between Parliament and the Executive, and in particular the Office of the Leader of Government Business, to facilitate working arrangements. And point number 5, I want to repeat what I've already said, that the committee agreed that ministers ought to respond to questions. And the committee confirmed the measures, and the committee supported the proposals given by the Speaker. Go on. However, the committee was of the view that, firstly, on point 4, that in the event of continuous non-compliance or lack of improvement, the Speaker should consider a reprimand, not may consider a reprimand, in the plenary sitting of the Assembly, and such reprimand be published fully in the minutes of proceedings of the NA. Number 5, as a last resort, the Speaker may escalate the matter through a formal complaint directed to the Leader of Government Business, and not necessarily to the President. So, honorable members, the proposal by the subcommittee is what we have in front of us now. And can you just move it so that it starts from Roman figure 1 on the screen? Yes. So it basically says this is what the subcommittee is proposing. The Speaker writes to cabinet members on a quarterly basis, request for reasons where relevant with regard to all questions that are late or not replied to. 2, the Speaker writes to the Leader of Government Business also quarterly, informing that office of the outstanding replies and correspondence sent to affected ministers. 3, a report on the responses by ministers regarding unanswered questions be submitted to the Rules Committee for information and published in the ATC announcement tables and committee reports for the information of all members. 4, in the event of continuous non-compliance or lack of improvement, the Speaker should consider a reprimand in a plenary sitting of the Assembly, and such reprimand be published fully in the minutes of proceedings of the Assembly. 5, as a last resort, the Speaker escalates the matter through a formal complaint to the Leader of Government Business. Deputy Speaker, that is the submission of the subcommittee on the review of rules in terms of a mechanism for monitoring and replies to questions. Thanks.
Okay. Thank you very much. Let's get the response of members. There's the report presented on behalf of the Chief Whip, who technology unfortunately disappointed by not working properly. Let's have your views. On the
My
mechanism.
hand is up.
Okay, now that I see it's up. Yeah. I now see it as you speak. Only then did it come up. Honorable Majodina. Honorable Janchi woke me up to that earlier. So I've been watching it here. Go ahead, ma'am.
Thank you very much, Acting Speaker, and greetings to all colleagues on this platform. I stand to welcome the report from the subcommittee, but if they can just flight Roman figure 5. Questions is part of oversight and holding executive accountable. That I fully support. On Roman figure 5, as a last resort, the Speaker may escalate the matter through a formal complaint directed to the President and copying to the Leader of Government Business. That is where I am not supporting, Chair. I'm not supporting it in that formulation because we have the Leader of Government Business that is dealing with all issues between executive and legislative arm, and therefore my submission would be that Roman figure 5 should then say when all the above has not happened and there's no improvement in terms of that, then let the Speaker call the Leader of Government Business in the House to be able to tell us what is the action that the Leader of Government Business is going to take, or in line with what has not happened, instead of escalating the matter to the President. That's my submission. Thank you very much, Acting Speaker.
Okay. Thank you. There's the slight amendment. It's not slight, it's significant, to Roman figure 5. Honorable members, please respond. Yes, Ndati?
But may I just explain something, sir? Maybe I committed to do this. Where you see the bold and underline, that is the proposal from the subcommittee. So when this proposal came from the speaker, for instance, on Roman figure 4, it had may considered. Now the subcommittee said, no, remove may. So in brackets, it's being removed, deleted. So it will say should.
So that it's not an option. It must be done.
And the same with Roman figure 5. When it went to the subcommittee, it was directing to the president, copying LOGB. The subcommittee said no, deal with the leader of government business. So here, the proposal is that you deal with the leader of government business. Thank you.
Okay. All right. Okay. Okay, we hear that. But let's proceed. Let's hear what members have to say. Other members who were not in the subcommittee, and including those who were, but respond to the suggestions that have been made.
Acting Speaker, it's Tasha. My hand's also up.
Tasha? Yes, go ahead.
Thanks very much, Acting Speaker. Acting Speaker, as you know, my colleague Jordan Hill-Lewis, who is the DA whip in charge of questions, made a lot of submissions during the last meeting. However, I would just like to alert the committee to one concern that we have, and that is the use of the word reprimand and what reprimand actually means. Because, I mean, I'll use a practical example. I have been reprimanded in the House by you, and because of the nature of the respectful relationship we have, it's embarrassing for me to be reprimanded, and it's certainly something that I would never want repeated again. And you know, it's my way of thinking that to be reprimanded in the House is a cause of great embarrassment, and I would certainly do everything in my power not to be reprimanded again. But we have to be honest, and we have to look at the ministers who are continuous, how can I say this, breakers of the rules. Let me use it in a very frank term. And those who are continuously at fault for just simply not abiding to the rules. Now, a reprimand for them is nothing, quite frankly, because yes, you stand up and you get told, well, you've been very naughty and please don't do it again. And this is not the way the House functions. But clearly we see that a minister who would allow themselves to get into a position such as this won't actually respond to a reprimand the way in which we would hope them to respond. And I'm a firm believer in giving someone a first chance. And then if, you know, catch me once, it's, you know, you fool me once, but fool me twice, and then it's a problem. And I think that by the time it starts to escalate to where we are thinking of calling in the leader of the government business, I think we should start looking at a financial reprimand. And I think that we've learned through Parliament that the only thing that really affects people who continuously break the rules of Parliament is in a financial situation. And given the fact that a minister holds such a high level of the country's confidence, and given the fact that the rules are such an important way for us to hold the executive to account, and given what has come out of the Zondo Commission in terms of accountability, and the fact that we as members of Parliament are blamed for not holding the executive to account when we've done our job, but the ministers haven't done their job in answering us, I think that perhaps we should put there and add a reprimand and a financial deduction or fine. As we deem so fit. So, for example, if it's a third offence and it's questions that have been outstanding for 3 months, then we dock them 1,000 rand per month that they have been behind on their questions. And Deputy Speaker, it's radical. But I think it's time for us to realize that if we want our parliament to function, we have to be radical about these things. And quite frankly, the only thing that will hurt a serial offender is if we hurt them in their pocket. Thank you, Acting Speaker.
Thank you. Okay, let's get to hear other responses. That's Honorable Tasha's view on the matter. Let's hear others.
Chair, I don't know if you're calling us in order, or can I just go for it? It's Mr. Hill Lewis.
Yeah. I know. Go ahead, Honorable Hill. Go ahead.
Okay, thank you very much, Deputy Speaker or Acting Speaker. Let me say I'm a member of the subcommittee, so we debated these issues in the subcommittee, but I just want to speak in support of both of the chief whips, actually. I agree with the Mrs. Majidina that the complaint should be in the House,
Oh,
that
please,
the leader of government business...
Sorry? I'm single and still looking. Single and still looking. I'm not Mrs. I'm Miss. I'm single and still looking. And looking for you.
No. This is not Tinder platform, please. Honorable members, Honorable Hill Louis, please choose your language carefully.
Okay.
Go ahead.
All right. So I think that the explanation should be given in the House, what the leader of government business is going to do about the complaint, and I think that does escalate it and make it much more serious. And I also want to speak in support of Mrs. Mazzoni's proposal around the financial sanction. Other than that, I expressed myself in the subcommittee. Thanks, Chair.
Thank you. Next time, just use Chief Whip. You won't be in trouble. Okay, let's hear other views.
Thank you, Chair. My hand has long been up.
Yes.
Can I go?
Yeah, go ahead, Ndati.
Ndati. Perhaps also as a member of the subcommittee, the first point that one should make is that I want to agree that the report as presented and circulated to us reflects our discussion as a subcommittee in relation to including the limited amendments that were made in point 4 as well as in point 5. But I must also indicate, Chair, that there are other issues that have been raised in the recommendations earlier before this, the general recommendations. Some of them are once-off kind of steps. And one of the key steps we have taken there was this issue of the interaction between the leader of government business as well as the presiding officers, which is a deputy speaker and so on in the process. It is in the report, but obviously it's not in the 5 points, because what we have also discovered is that there are certain failures even within ministries, including ministry staff, and that in a way of a workshop to start off, we need to do that, and therefore the issue of the interaction with presiding officers, I wouldn't want that to get lost in the process. That would be my first point, Chair. The second point, Chair, I hear what Honorable Natasha Mazzoni is suggesting, but I do want to make this point that the ministers are also members of parliament. And I think we should be allergic to do rules for them only, because there are rules in the House, because the issue we're dealing with here is people who don't comply to rules, who are not responding to the rules that have been set. You can imagine a member in the House who is a perennial non-compliance, who makes the noise all the time and do all of that. You don't invoke financial sanctions there. So I really wouldn't support in this regard this issue of the financial sanctions. because I think we have mechanisms in the House, in our rules, for a kind of severe penalties or wrongdoing. So I want to not endorse that, unfortunately, Honorable Lewis and Honorable Mazzoni, because I think it will create a kind of a wrong perception, because you've got to look into the entirety of this. When you look at those 5 points, the reprimand comes in point number 4, but there's an issue thereafter, which is point number 5, that as a last resort, the speaker may escalate the matter in a formal way through the leader of government business. And so there's an expected action to be taken when somebody is not complying in terms of point 4. And so it will be very much preemptive and premature to then in point 4 even want to include issues of a financial penalty in that regard. So for that reason, Chair, I'm not in support of that. But since you said we must, because I want to move to the earlier issue around those who've responded and not responded, because this is one document. If you allow me, Chair, just
go ahead.
Just one or two comments on that one, because the picture that we're given here we're told 24 ministers have been written to, and that comes to about 140 questions. And in summary, the last document says to us, Honorable Chair, 1,767 questions were asked by members. 1,767 questions were asked. 1,701 were answered on time. And then you have got 1,223 that were replied late in terms of that summary. It's not a good picture to make the point. And then you have because we're told who responded as required, and others did not respond at all, except to just provide the answers that they needed to provide in a 10-day period. I think the mechanism we're adopting here is really going to help us in relation to that. Because when you look at some of the reasons that have been provided, some of those who provided, it's certainly, Chair, for me, when a minister says the matter is under investigation, that's a reason for us to accept, because you can't, because you'll be compromising that investigation. But such explanation needs to come forward. But an explanation that says, no, this matter involves provinces and municipalities is certainly not helpful in that 10-day period, because then you then have a situation that says we couldn't respond on time because we have, which I understand. There are apartheid era information that we had to dig and all of those kind of issues. I guess the point I'm trying to make, Chair, is that I'm sure in your capacity, immediately after this meeting, you might want to invoke some of what we're going to agree to here today. And I would urge you to do that. That some of the steps were taken, get onto it immediately, because the picture is not good when it only 3-4 ministers out of 24 that responded. And so it doesn't say much good about the respect to this institution that we're leading. I wanted to just make those brief comments in relation to the other, because I think the historical problem is not a good one, but I think what is presented here today from the Speaker, amended by the subcommittee, is beginning to say we have a way to correct this, and in correcting it, we're going to have to be very firm and very consistent in dealing with that. I thank you, Honorable Chair.
Thank you very much, Tate Janchi. We appreciate your comment. Honorable members, I saw the hand, I don't know whether it's an old hand, of Tasha from the DA. Can I ask you, Tasha, to hold on, please? Allow me to just a little bit to facilitate so that there's broader input into these processes. I see there are other political parties who are here in the Rules Committee. Can they speak, please? Let me point.
Just to also make the point, Chair, sorry to come in that
okay.
That subcommittee, there were two parties that were present. It was the African National Congress and the DA. Others were not there.
Okay. I see Dr. Mulder is here. Could I speak, please? Dr. Mulder, are you there? Would you like to comment? Well, in the absence of any other comment, let's invite second bites from any one of the speakers who are. Thank you very much for that information. It tells us an important story. Why perhaps, that you were the only two parties in the subcommittee. I don't understand why others are not here. Honorable Tasha and Honorable Majodina.
Thanks, Deputy Acting Speaker. You know, Acting Speaker, there are a few House Chair people that I think have come in and done a really good job, and I think Honourable Jantjies is one of them. And it's very rare that you'll hear me congratulate a Chair of the House. So you must understand that I mean that with sincerity. And I like it because I like the stern discipline that Honourable Jantjies brings to the House. And everyone has their own way of doing things. You diffuse a situation with your good humour and the fact that you know us all so well, so you know our quirks. And Honourable Jantjies is a disciplinarian. And sometimes that is absolutely needed. So I want to say to him that I actually agree when he says that we should extend the financial burden, not only to ministers who are members of the House, but also to serial offenders. And I do wish to point out that there have been times where people have been thrown out of Parliament and have had to have had their salaries docked, and rightly so. Because you see, it's the absolute disdain for Parliament that we need to get rid of. And it's crept in over the years. And I know it frustrates you. It frustrated the then Speaker. It's frustrated the chair people. And it requires that kind of radical action. So I want to suggest that Honourable Jantjies and I are not that far off the spectrum in regards to how we view discipline being doled out. I think in real life, neither one of us are a disciplinarian. But when it comes to work, I think we both believe in adhering to the rules. So quite frankly, it's always been my opinion that if you get to the stage where you have to be thrown out of the House, there should be a financial consequence, because you've been thrown out of the House and you're not doing the job that you're being paid to do. So you should therefore suffer financially for it. And right. I think it's the same with the ministers. So I'd like to suggest to Honourable Jantjies, just give it a thought, because I don't think we're too far apart on this one. Thank you, Acting Speaker.
Thank you very much. Honourable Majodina, I'll come back to the matter that Honourable Mazzoni is addressing. Please go ahead, Chief Whip. Or is this an old hand?
Oh, no. New. It's new.
Okay.
It's a new person.
Okay. Good. Renewal constantly is a good idea.
Thank you very much, Acting Speaker. Acting Speaker, as whips who are also participating in the Rules Committee, we want to assure presiding officers that we have a responsibility, and we know our responsibility, and we are embracing and enhancing our responsibility, that of ensuring that the decorum of the House is respected at all times. And therefore, I want to piggyback on what Honourable Mazzoni said, to request that this Rules Committee refer this matter on reprimand, that after a verbal reprimand and a person continue to be an offender, then how do we then move a step further? So I want to take that matter back to the subcommittee to look at the matter and bring it in our next Rules Committee.
Yes, okay, all right. Okay, all right, thank you. I hear you. Honorable members, can I suggest that perhaps what we are seeking to do may not have happened before? In other words, the increasing a focused attention on non-compliance with request for questions. The last presiding officer who called, okay, no, it was a slightly different, it was a member, not a member of the executive. So we haven't really in the House reprimanded a member of the executive for not answering questions. And therefore we don't have a basis, a foundation for suggesting that they won't if they are reprimanded in the House. That is yet to happen. Unless you have a contrary view, evidence that I'm not aware of, that we have ever done so in the House. So this is an important step in that direction, Honorable Mazoni. I'm addressing you on this thing, that we haven't done that. We haven't in the House reprimanded a member of the executive for not having responded to answers. It's members who have complained about it and repeatedly raised issues with them, but not the presiding officers calling on any of the members of the only person I reprimanded in the House was the president and Honorable Steenhuisen. When the president offered him, I didn't even reprimand him firmly enough on reflection. The president offered Honorable Steenhuisen a cigar in the House. And I complained, how can you offer each other a cigar in the House? It was not, the point I'm making about it is that we should give an opportunity to the rules that we are adopting today, firstly, to highlight the significance and strategic value of questions to the executive as a critical aspect of oversight and accountability. So if we are being told that we have not acted firmly enough to demand accountability, this is the one approach we are adopting today to move in that direction significantly. As a result, not only of members inside the House, but also of people outside looking at what we are doing. So I suggest that on that ground, we accept the proposals and work on them. And as proposed, as added to by Honorable Janchi from the notes, that we as assistant presiding officers of our principals, we will be active in interacting with the leader of government business to point out this month, this is who is threatening to go over the line. Let's speak to him or her so that this is nipped in the bud before it develops into any problem. So in the mechanism as proposed, the addition that the deputy presiding officers will act in order to fill up so that before any escalation, we have taken proactive steps in advance so that we don't even reach that. If we reach that, it must be an extreme example. So if that is the agreement that we have, we would like to thank profusely the work that's been done by the subcommittee in responding to this matter this way. We will now, I believe, take this for adoption by the House as a way of handling our affairs. Is there any matter that on this question that we haven't addressed? Is this summary okay, members? Any objection to it? Honorable Buroto, I see your hand.
No, thank you, Acting Speaker, I just want to say that I want to support what the Chief Whip of the majority party said in terms of taking back to the subcommittee the issue that the point 5, if point 5 fails, what do we do? But as we would be doing that, let us not forget that these are members of parliament, and this has got to be coined with what we have in the rules presently about such issues and what are the implications and what will happen after that. Thank you.
Yes, no, I agree, especially because Honorable Janchi was citing that. I see your hands there. I'll come to you just now. Was actually saying, he will confirm this, that we would rather not use such a rule for executive members. But then Honorable Mazoni wants to extend it as if he was agreeing to its extension. And I didn't hear him say that. He was pointing it out as maybe it's an aberration. And if we need to act on it, let's go and find out. What I'm saying I agree to is that let's continue to assess and evaluate the most effective mechanism. I thought that what we suggested, that a proactive system of interacting with ministries and the teams that support them is an important part of cleaning up the process. This came out. We agree with that we should go and interact actively to understand better in the linkages between parliament and the ministers themselves. That process is an important one to examine, so that we can, if it is the role of parliament, perhaps, to clean up its effective interface and support to people who link with it on behalf of ministers, we clean that up as part of the process of ensuring that we are effective in dealing with this question. So it's a correct way to deal with it. So the subcommittee, and we must continually be observing where else are gaps emerging, so that we reinforce our responsiveness. Dade Janchi, and on behalf of the leader of government business, I see Gerard is also raising his hand finally. Yeah.
No, Chair, mine was brief too. I was raising my hand in support of your summary. I thought your summary is taking us forward, because it does not negate the other issues that were raised. Because you are saying here is a new chapter, let us test the new chapter kind of going forward. So I'm in support of that, because I don't see it as mutually exclusive to as we execute that, for us to look into the other issues. Thank you, Chair.
Thank you very much. Gerard?
Acting Speaker, I fully support your summary, but just to formally propose then, that we accept and adopt the recommendation of the subcommittee as proposed in 5C Roman 1-5, formally. We need a formal approach and to say we agree as a rules committee. Your summary. Yes. Thank you.
Yeah, as amended in the process of discussion. Yes, thank you. Do you propose, Gerard?
I formally propose the adoption.
Who seconds Honorable Kuronov? Is that you, Honorable Boroto? I see your hand is up.
Thank you. Yes, thank you, Acting Speaker. I want to second the proposal
adoption.
by, yes. Thank you.
Thank you very much, honorable members. This item is disposed of in that good way. Thank you very much. Let's move to the next item there. Briefing on the implications of the court order on Section 194 process.
Deputy Speaker, we will be led by legal services on this matter.
Okay.
We need to come in later on.
Okay.
Thank you. Good morning, Acting Speaker. Good morning, honourable members and colleagues. Acting Speaker, with your permission, I'm with Dr. Barbara Lewitz. I will start the presentation. If I can just flight our slides.
Yes.
I see it's on. It's on. Okay, great. If I can just ask the colleagues to go to slide 2, please. Thank you. Acting Speaker, to the honourable members, there was 2 cases that kind of coincided and resulted in one judgment, the Public Protector versus Speaker and the DIA versus Speaker. In both cases, the substantive issues was a challenge to the new rules giving effect to Section 194. So the court decided to hear these 2 cases together, and that resulted in one judgment. We can go on to, I basically just said that, so we can go on to slide 4, please. So the judgment primarily speaks to the Public Protector versus Speaker, but it also disposes of the arguments that was raised in the DIA matter. In general, the High Court found that the rules that the National Assembly adopted in giving effect to Section 194 of the Constitution is procedurally fine, but there was 2 instances that the court took exception with. So in general, it said the rules are okay, they're constitutional, but just with 2 points that I will discuss below. Everything else was found to be appropriate. So if we go to slide 5, the first issue that was raised was the Audi Ultram Partem issue, where the applicants, the Public Protector and the DIA argued that the new rules breached the right to be heard. The argument was based on various aspects of the multi-step process in the new rules giving effect to 194, but the primary focus was a concern or a complaint that the Public Protector was not consulted before the Speaker found Honourable Mazzoni's motion in order and before the independent panel was established. So the court looked at that, it considered, and then the court held that when you look at Audi Ultram Partem and the right to be heard, one must be cognizant of the circumstances of every set of facts. And when it comes to the multi-state process, the court then said you don't have to have a hearing at every stage or opportunity to be heard at every stage of that process for it to be a prerequisite for legality as far as the context of the new rules are concerned. So the court found in that aspect, with regard to be heard, that the new rules were rational, and it disposed of that concern. On slide 6, please. With regard to concerns of unreasonableness, the Public Protector argued that her dignity was also infringed by the fact that she was not consulted prior to the motion being found to be in order, and she said that was unreasonable. The court found that in dealing with that, in dealing with the motion, the new rules are not arbitrary or irrational. The court also found that the Speaker is not at liberty to ignore a motion once it lands on her on the desk of the Speaker, and therefore the rules are compliant in that aspect. The process and the Speaker's action, actually the court found, advanced the principle of openness and transparency, and the court found that the Speaker did not act with any mala fides or ulterior motive, and any such assertions were unfounded. If we can continue to the next one, thank you. Then with regard to the independent panel, initially when the challenge was brought, the Public Protector only took issue with the inclusion of the judge. But during oral arguments in that Part B phase of substantive argument consideration, that concern was broadened to a general objection against the independent panel as part of the 194 process. And the court held that the National Assembly is at liberty to seek advice. It is also at liberty to ignore advice once given, but nothing in the rules, in the new rules, gave the discretion of the National Assembly away. It retained the discretion, and therefore there's no issue with having an independent panel. They can advise, the NA will consider, and the NA makes that decision. So the court found that to be fine. What the court did have an issue with was with the provision of the judge to serve on the panel. The court found that it's undesirable for a judge to be part of the independent panel because it is a political process, and it found that it offends the principle of the separation of powers. What the court did in this instance then is they didn't just say that the rules are invalid per se because there was a provision for a judge to serve on the panel. The court opted to sever that reference of the judge in the new rules. So it took the reference to a judge living on the panel out and said, but the rest of it, of the rules, will then be fine. If we can continue. With regard to legal representation, this is the second other issue that the court found Parliament to be wanting on a little. The rules as it was crafted, 129 AD, apologies, 3, said that a public office holder has a right to be heard and has a right to assistance with a legal practitioner, but did not allow that legal practitioner or another expert to participate on that office bearer's behalf. The court held that although the public protector as a Chapter 9 incumbent may have legal qualifications, other Chapter 9 incumbents don't have that same qualification or legal qualification standard. And therefore, it said that full legal representation should be allowed. And again, as with the judge, the court said it's not going to just declare the rules invalid. It's rather going to opt to sever the words, to take out the words, provided that the legal practitioner or other expert may not participate in the committee. So those were the two niggle points. And then with retrospectivity, the public protector also alleged that the new rules could not apply to her because it was only adopted on 3 December 2019 by the National Assembly, and therefore only after did it have effect, or only for that period or thereafter the rules were in place. So you can't use it before. And the court held that position would render the National Assembly's oversight function inoperable. And it would basically mean from the inception of the Constitution up until 3 December 2019, the National Assembly would be prevented from exercising its Section 194 oversight obligation. And that would lead to absurdity. So the court did not agree with the alleged retrospectivity concern raised by the public protector. If we can go on to the next slide, please. The grounds for removal. There was an argument made that the rules altered the grounds for removal as found in Section 194. The court did not agree with that. The court ruled that the new rules provide the operational standards set in the governing and empowering legislation and Section 194 of the Constitution. So the definitions of the grounds of removal as linked to the new rules do not alter the constitutional grounds. So the court found that the grounds were in order. And then also with regard to the issue of double jeopardy, the court held that this is not a double jeopardy issue. The public protector's removal from office question is a function exclusively reserved to the National Assembly. It's not a matter of a criminal nature. So the issue of double jeopardy does not come into play. Online, thank you. With regard to the conflict and request for recusal, the public protector called for members of the National Assembly who are perceived to be biased to be excluded from the Section 194 process. And the court said, but until proven otherwise, it must be assumed that members will act in terms of their oath taken for Schedule 2 of the Constitution, wherein they undertake to uphold the Constitution. And then Parliament has its own structures in place if a member does not act appropriately to deal with that. So the issue of conflict of recusal was also discussed with, and the court said, no, that's not an issue. If we can go on to institutional independence, the public protector then took another argument further, and it alleged that the DA sought through the impeachment proceedings to meddle in court cases under the guise of holding the public protector to account. The court held that the court could not remove a public protector. So they're having a motion or bringing a motion and having a process that looks into the possibility of impeachment is not something that a court can do. So there's no meddling with the one arm into the other arm there with regard to the separation. A court process was different from a National Assembly Section 194 inquiry, and it would be an anomaly if the NA could not exercise its oversight function in terms of Section 194 purely because there were judicial pronouncements. And it is for the National Assembly through its impeachment process then to determine the veracity of the allegations in relation to an office bearer's constitutional obligation. So therefore, in summary, acting as Speaker, the court in general found the new rules to be constitutionally sound. The public protector's application was successful only with respect. The court found no they can. So it wants the rules to allow for that. And then with regard to the reference of the judge, the court said no, judge should not serve on the panel, and it severed that provision. Thank you, Acting Speaker.
Thank you very much. Let me make this comment and then open this for discussion. The court, in its decision, now this is a lay person speaking, should have anticipated the consequences of its ruling on the matter of what you call, I don't know why you choose such English, severing a presence of a judge in the panel from the rules. In other words, excluding a judge. But the judge was involved in the panel. So what are they saying about that having happened already? And why did they have to leave it unattended? Because as I would say, they're now eating our time. So we must go back to seek clarity on this matter. I'm just raising it as a concern that they should have anticipated the consequences of their ruling without making any decisions for us, but the legal consequences of the decisions they were taking. Okay? I'm just raising that for us to talk about as we do so. Let's comment on this. Legal services have presented us this matter. I see Dr. Mulder, I'll start with you, and then Honorable Kasha, and then Honorable Pemi.
Thank you, Acting Speaker. I would like to start off by thanking the legal services for, I think, an excellent exposition of the court case. I think they're absolutely correct. If we look at the judgment itself, then as correctly was pointed out, the judgment confirms that everything is basically in order in terms of the rules that Parliament adopted and the processes that we have followed. They have questions with regard to two aspects. The one being the legal practitioners assisting the Chapter 9 heads, that they should be allowed to act in and participate in the proceedings. And the second one, the question of the reference to a judge as a member of the independent panel. Chairperson, my view is that the court are wrong on both instances. I think they've made a mistake, and I would say why I would say that. With regard to a judge on the panel, it's not unheard of to involve the judiciary or judges or then retired judges in different processes where it's needed. For example, the Electoral Commission has just used retired Judge Moseneke to do some work for them. With the Ghana incident, it was also retired Appeal Court Judge Farlam who was then asked as a retired judge to get involved. It's normal to use judges for those kind of things. They've got legal expertise, they've got some experience, etc. I don't have to argue that. In our specific case, it was not a judge, it was a retired judge that participated. So I would interpret the court case to say a judge should not be involved. I think they are wrong in the first instance, but in the second instance, the panel was led by a retired judge, and my view would be that it would have no effect on the process up to this point in terms of that, because it was a retired judge, and I think even the pronouncement they made is we should think about appealing that. The second one, with regard to the activities of a legal practitioner, where the public protector should be allowed to have a legal practitioner, the court says that practitioner should not only advise, but should be allowed to participate. Once again, I think the court is wrong. I think the judgment is wrong. And if you talk about interfering into each other's processes, then I think it's interference into the legislative arm of government. The Constitution says how we should set up our committees. The Section 194 investigation is not a court case. It's not a court. It's a parliamentary process. And if anyone involved in that process is not happy with the outcome, that person can afterwards take some administrative action and take the whole process to court if somebody wants to question that. But if we take that recommendation by or that finding by the court seriously, it would mean that all our processes will now be in a different vein, that legal practitioners will be able to come and participate in all our committees. It's a wrong decision, and I think it has no effect on the working of the committee up to this point. The committee should continue with its work, and I think Parliament should seriously think in terms of appealing those two specific findings. Thank you, Chairperson.
Thank you. Yeah. Go ahead, Honorable Tasha.
Thank you so much, Acting Speaker. Acting Speaker, I like you, am a layperson when it comes to issues like this, but I have studied the judgment very closely. As you know, it's my motion, so of course I'm intimately involved and intimately know the contents of the motion, and of course was cited many times during the court case. I think what's important to note, and what I've learned in my career, is not to necessarily say that the court is wrong per se, but I think that courts interpret the political sphere in a very different light to the way politicians who are in that specific arena interpret the role that we play. And that is normal because, the judges say the law, they don't make the law. There's a legal maxim that says that. So I think that we always need to remember that judges err on the side of caution, and we must always accept that we would rather have a judge that errs on the side of caution than goes wild cowboy and doesn't err on the side of caution. But I would like to wholeheartedly agree with Honourable Mulder in that we could never expect a legal representative, for example, to come and represent a member of a board or a DDG or a minister, for that matter, should they appear before Parliament, because we are a parliamentary committee. We make it very clear that although Parliament has the power to summons, that we are not a judicial body in and of ourselves, and that we make referrals. And I think we can use the ESCOM inquiry as the perfect example. We decided to refer the findings of the ESCOM inquiry to the Zondo Commission, which was duly done and has been studied now by the Zondo Commission. And I'd also like to agree that there is a vast difference between bringing in expertise, and if that expertise happens to be a medical doctor or a retired judge, I certainly don't think that that has any interference with the various arms of government, because a retired judge is not allowed to appear before the bench anymore. They're not actively on the bench anymore. That stage of their career is finished. And we are very lucky in South Africa that we have an abundance of retired judicial officers that we can call on, and we have called on many a time. So what I suggest, Acting Speaker, is the following. I suggest that, and I've said this from word go, the appeal should go in, and that Parliamentary Legal Services should work with the NA table and those who are involved intimately in the case to explain the way parliamentary committees function and the way they are established in accordance with our own rules and with the rules of the Constitution. And then I also suggest that we don't let this hinder our work as we go forward, because we haven't let any of the court cases hinder our work. This is the second court case, or maybe even the third, in this particular arena. And we haven't let it hinder our work. Our work must continue. There is a problem, and this problem must be addressed. So I think that the summary given by the State Attorney is absolutely correct, the State Law Advisor. And I think that the court was actually very fair in the way they didn't demand that anything was brought to an end, and they didn't demand that anything was changed, because they know that we ourselves are an arm of government and that we have our own work to do. So I would strongly urge that that appeal goes in immediately, but that the Section 194 committee continue with their work. Thank you so much.
Thank you. Honorable Pemi Matutina. I won't call all the other names you call on your system.
Thank you very much. Acting Speaker, let's appreciate the good work done by our legal services. We fully support, as ANC, we fully support that let Parliament, through the presiding officers, appeal on both findings by the court. Parliament is an arm of state, or legislative arm of state. We are a legislative arm of state, and therefore, the separation of powers should not only come when it fits judiciary. They must also respect the separation of powers when it comes to the legislative arm. The matter of a public of a legal representative speaking in the panel of inquiry, that will in a way turn the panel to be a court sort of a trial, and therefore we support that we appeal against this too. In that appeal, it is important and very imperative that the judiciary must be able to give clarity in terms of a declaration order, so that we get clarity at what stage can judges be used and not to be used. With the argument that has been put forward by Honorable Malta and Honorable Mazon, at what are we not allowed as Parliament to utilize the services of retired judges? If no, why? If yes, up to where? Then the other matter is on the issue of that report of the independent panel. According to this report and the ruling, the report has not been nullified, and that report is serving as a terms of reference for the panel. Secondly, the rules of Parliament, which I appreciate, the rules of the National Assembly has not been nullified. So the only thing that we can do is to put on hold the functioning of this committee right now up until this process of appeal goes through, so that we are not seen as undermining that ruling. Because if we are going to use the independent panel report as a term of reference, when we don't know what will be the outcome of that appeal, and that appeal must seek clarity at all fronts, we support that. Thank you very much.
Thank you very much. Just to say that, honorable members, once the appeal is registered, the decision of the court is suspended. So I nearly used a political reference to say that the work must continue. You know what I'm talking about. So I request that, with respect, Mema Jodina, at least part of it, but say that because the law says so to us, immediately the appeal is registered, the legal people are here, they'll advise us. Once it is registered, we proceed. In other words, because nobody has stopped us effectively. This is absolutely critically important in our understanding of what the next steps should be. So let me give Ndade Khaso and the legal team, if there is any comment on that, because on the legality of what the implications would be if we proceed on the understanding that, as you correctly said in your part of your summary, Chief Whip, none of the work we are doing has been nullified, except for perhaps those comments about an involvement of a judge, and not on the work they have done already, for example. So let's do that. Let's hear the team, led by the Secretary of the National Assembly.
Thank you, sir. Certainly, I would like to recognize the legal team. I see both Dr. Woods and Mr. Njigela are here, just to comment on the risks of continuing with the process while we still have these two issues to clarify, the legal risk.
Yes. Yeah.
Legal analysis.
Thank you very much, Acting Speaker. I will just limit my comments to the two issues that have been raised by the Acting Speaker, and with regard to the issue of the suspension. And of course, acting Speaker, I must say upfront that we have done an analysis of the judgment. And that analysis has been communicated to the relevant authorities and has just been shared with the committee by Dr. Lutz. And the approach we take is a simple one, as evidenced by the presentation now, that we had made very strong arguments on both points in as far as the utilization of a judge in the independent panel and the issue of legal representation, and the reasons are fully explained in our court papers why it is appropriate not to allow legal representation in what is a parliamentary process, not only in this instance, but in also other instances. Oh, and of course, the full bench of the Western Cape has found different from us. And that is an issue that is open to Parliament to make a decision on. The second issue of the use of the judge, again, we make the arguments about the status of the judge. Now, Dr. Lutz explained initially that when this process started and this challenge was mounted by the public protector, there was no judge appointed. All the rules provided for at the time was the possibility of a judge appointed, because that's what the rules say. Fit and proper persons with the necessary legal competence, and that may include a judge. It was never a directive that a judge must be appointed. And at the time these proceedings started, there was no such an appointment. But in the course of the litigation, of course, the game changed. And I think the acting Speaker made the point that at the time this judgment is delivered, there was a finding, not a finding, maybe that's let me use a different word. There was a report by the independent panel, which I suppose the court may have taken judicial notice of. But the court, in its wisdom, decided not to go as far as to set it aside. These are the issues that we are grappling with from a legal perspective. And our advice was, and this was done in consultation with counsel that represented Parliament, was that perhaps we have better prospects in as far as the issue of a judge acting or serving in the independent panel than we had with regard to the issue of legal representation. And the reason is simple for that, acting Speaker, was that the issue of legal representation, nothing has materialized in as far as that issue is concerned, because the inquiry has not begun yet. What the judges did in respect of that issue was to remove the proviso which denied legal representation before a committee, and they left it at that. So it seems to us that Parliament may still make a decision to allow, if it decides to proceed with the inquiry, to allow Advocate Mkhwebane representation before the committee. On the second issue of the judge, because it has an implication on the status of the report, on the basis of which Parliament had made a decision to establish the inquiry. So there are two different approaches that could be adopted, and we have made recommendation in as far as that issue is concerned. So I don't know if I can take it any further than what we have already stated in the presentation that we have made. But these are the options that are open to the Rules Committee to make a decision, and we will be happy to oblige with that. Thank you very much, Acting Speaker.
Acting Speaker. Sir. You're muted, Chair.
Sorry. Yes, yes. Go ahead, Ndati.
I wanted to suggest maybe so that we could, outside of the meeting, we could ask legal services to advise your good office specifically on the implications of continuing with the inquiry while these issues have not been clarified. I think that question has not been answered. But maybe
yes, it has not been. Okay. Yeah. All right. Risks must be assessed from all sides. What are the risks for not continuing? What are the risks for continuing? So it should be a continuum. Dr. Mulder, I see you have got your hand up, and Honorable Makwanishe as well. Please, let's hear you in that order.
Thank you, Chairperson. Just 2 points. The one is I've listened to what Legal Services just now said in terms of the current wording of the rule.
Yeah.
Where it basically says that the panel could consist of legally qualified people, including a judge. If the court's judgment's got a problem with the wording of judge, then I would think we could amend that specific provision to say an ex-judge, because we did use an ex-judge. It wasn't a judge, it was an ex-judge, a judge.
Yeah.
That's just the second one is with regard to the possible implication of continuing or not continuing. I would warn from my side against not continuing, because if we stop the process, this could be drawn out for the next 3-5 years, appealing from one court to another until we end up in the Constitutional Court after the expiry of the term of the Public Protector.
Okay. All right. Honorable Makwanishe.
No, thank you, Acting Speaker. I think I want to align myself with the views that were expressed by the Chief Whip. I mean, if we are going to appeal the issue of legal representation, that is a very weighty issue. And if you are appealing that, then you can't proceed until there is clarity on it. I think it's a very weighty issue, and I think we would need to get certainty around it. So I would align myself with the Chief Whip, and also the issue that was raised by Dr. Mulder. I don't think that we have used a retired judge. It's a judge that has been discharged from active service. Because we have 3 kinds of judges. We've got judges that are in active service, judges that have been discharged from active service, and then retired judges, those judges that have reached the age of 75. So a judge, Besson Kabinda, was a judge that has been discharged from active service. But I do think that the issues that the Chief Whip has raised, I mean, if we have to appeal the issue of a legal representation, it's a very weighty one. I do think that let's wait for the appeal. Thank you, Chair.
And okay, all right. Okay, honorable members, let's the manner in which, okay, let me leave this to, let me put it this way. Firstly, the arguments you're putting across, please lower your hand, Ndate Magwanishe. The arguments you are raising are significant, but we have made the points, you have made the points and so on. Let's go and consider the advice on how we can frame the appeal so that the matters that we appeal are of such nature that they can be handled with expeditiously. And the principal word for me there is expeditiously. How we can persuade the courts out of respect for the functions we each have, that it may be necessary that this matter be dealt with expeditiously. Let me leave it there and then have a discussion afterwards on how we take this forward. Okay, is that okay, members? We will keep you posted every step of the way. Yes. Okay. All right. Thank you very much. Let me see where we now. The next item. The input on the rules regarding the elections of office bearers. Who leads on this?
Deputy Speaker, with your permission, sir, I may.
Well, go ahead, Ndati.
This point arose yesterday at the meeting of the program committee. It relates specifically to at what point could nominations be made for election of a speaker, and I would like to perhaps say of an office bearer whose election is regulated by the Constitution. And the suggestion was that maybe nominations could be made not during the sitting itself.
Do this so that we don't take for granted. When you make the change in the wording, explain your reasoning. In other words, why you choose office bearer instead of what was there, so that it's clear to every one of us. We are part of the shop here, but there are others who are listening to us who may not be familiar. Don't take that for granted. Please clarify it for us.
Certainly, I will. The rules that we're discussing relates to the election of a speaker, president, deputy speaker, premiers, speakers and deputy speakers of legislatures. So that's why I'm using office bearer, so that everybody's offices. And it's the same set of rules applicable to all offices. Now, so the suggestion was that maybe we should make a submission to the Chief Justice, that office, to say that nominations could be made beforehand, not during the sitting, so that Parliament or any other structure does not have to get into a lot of logistics preparing for a secret ballot that might not take place had we known beforehand. And that was a sense from the meeting yesterday of the program committee. And so we want to make the following suggestion, that submission should still be made to that office, and we would work with legal services and of course through the office of the speaker. But we want to suggest that the input be made in respect of future instances, not the one we anticipate for next week. That's number one. Two, that proposal be made in respect of what I would refer to as casual vacancies. These are vacancies that occur mid-term, like we have currently. And the reason is simple, that for elections that take place at the start of a parliament, you can only elect people who have been sworn in as members of parliament. You can't nominate before people are sworn in as members of parliament. And therefore, it has to take place on the same day, the swearing in of members, the nomination, and the election of the office bearers. And this proposal for a nomination that is done beforehand will not work in that respect. So that is our submission.
Okay. I hear two parts to your proposal, that the rules that have been suggested, and these are the rules that must be approved by the Chief Justice, if it is the Chief Justice, right? Or his or her nominee.
Yes,
is that correct?
Chief Justice. Not
Chief Justice, yeah. Yes. So this is a proposal. He has to accept that and so on. Now, to the extent that we have, it may apply to other parts of the legislative sector. And this arose as a result of consideration that we have COVID and the additional complications will be added to and so on. So we need to be mindful of that. So there are those requirements for the future as well as next week. And that decision will also be obviously dependent on the judge what he accepts and so on. So let me give the Chief Whip, Dr. Mulder and Tasha. In that order, please go ahead.
Thank you very much, Acting Speaker. Acting Speaker, to confirm what Mr. Kaso has reported here, in the NAPC, we said, let's look at the possibility of making a recommendation that we get nominations in advance so that we can, the Parliament can be able to prepare some logistics that are needed. We are wary of the situation and live to the situation that we are not operating under normal circumstances. We keeping people for more than so many hours might be unfair. We are raising that because we have experience wherein when the nominations are done on the day, we take a long time to deal with that. So we're trying to shorten the process without compromising the rules. Hence the suggestion that we have put forward. And therefore, this argument that let's take this matter for any other vacancy that might come in, I'm not convinced as yet. We still feel that let's explore this particular period to see if we cannot do that. All other matters, we are going to follow the secret ballot fiscal attendance that we support. But we're saying the logistical and administrative nightmare that comes up with with Parliament, where they are expected to do ballot papers, because according to the rules, the ballot papers can only be printed when nominations have been done. We're saying let the Chief Justice Office be engaged on this matter. But now, if we made that proposal yesterday, today the table staff is saying no, let's not do it without even trying. I think Mr. Castle sends a pansi. Thank you.
Chief Whip, I must protect him. How? We sleep and wake up. And so we must benefit from our good sleep. Dr. Mulder, it's your turn.
Acting Speaker, the Honourable Mazzoni raised a hand before me.
I'm in the chair, sir.
That's okay.
With
fine.
respect. With respect, yeah.
No, I understand the problem that we are dealing with, and I understand that we want to solve a situation. But I would warn that we shouldn't over hastily start to amend procedures in terms of getting people elected. If I may say, I think the chances that we will have an election and not one nomination only next week, I would say it's about 110%, that we will definitely have an election. So as far as I'm concerned, the staff can prepare for an election, that we realize. There's a need perhaps that this whole issue be also then referred to the subcommittee on rules and to look into the whole process. My concern is the following. The Constitution says in section 52, 1 and 2, specifically that under the circumstances, the House needs to elect a speaker when there's a vacancy, that we understand. And then it says in 52.3, the procedure set out in Part A of Schedule 3 applies to the election of the speaker. And if you then go to the Constitution, Schedule 3, Part A, and you look at subsection Part 2, it clearly says nominations. The person presiding at a meeting to which the schedule applies must call for the nomination of candidates at the meeting. That's what Schedule 3 clearly states. So even if you try to come to some kind of agreement, there will have to be called for nominations at the meeting, and parties will have the right to do so. So I can understand that we want to fix this, but I think for the current situation, we must understand, I think there will definitely be such an election. Thank you, Chair.
Okay, now the best for the last. Tasha, it's your turn now.
Acting Speaker, gallantry is alive and well in this committee today between you and Dr. Mulder. I feel very special. Acting Speaker, here is my concern. I agree with Dr. Mulder, and in fact, I can confirm with Dr. Mulder that there will definitely be a contestation for the position of Speaker. And I think that we would be naive not to realize that. But I also know that our courts are used too often to try and solve problems within Parliament that many times we cause ourselves. Now, I agree that we live in the time of COVID, and it would be much easier if we called for nominations before the time, and that the ballot papers were printed. But here's the thing. By doing that, you actually take away someone's right to just be sitting in Parliament and decide, maybe I want to be the Speaker after all. And if I may, sir, you yourself could be sitting in Parliament and decide, I'm actually really good at this job. And someone could agree with you, and you could put up your hand and say, I'm nominating myself. And I'm quite sure you would get a seconder. But my biggest worry, Acting Speaker, is that the courts, this will find its way into the court because we have deviated at such short notice from the rules and schedules. And I went and read the guidelines too. And the guidelines are also clearly indicative of the fact that nominations must be called for from the floor. So let's look at this for the future. None of us ever thought that we would be living in a pandemic. Let's be honest. We are learning as we go along, but let's avoid a possible court case. And I'm sorry that Mr. Kaso is going to have to do all of this on the spot. But, we have wonderful NA table staff. And for that, we are blessed. And I'm quite sure that they'll be able to handle the task on the day. Thank you so much.
Okay, honorable members. That's the things the work will proceed, and the Chief Justice will tell us these are the rules that I agree to or do not agree to. This is what we want to do. Let's do that. These are the rules for office bearers and so on. So whatever the outcome is, the work must continue. Like we said earlier on, that the subcommittees, the subcommittee of the Rules Committee, they must paint continuous scenarios and what rules we can then apply if needs be and the need arises and so on. They must be continually engaged in looking at the various scenarios that we may have to deal with. But as agreed, so let's take the proposals that are coming forth. Let's present them to the Chief Justice and see what comes out of it. Okay. And mindful of the risks that we are talking about, both from the pandemic side and from the legal and other consequences that might delay things that we have to achieve. Honorable members, the next item. Slide it. Yes. The proposal to establish a new portfolio committee. Ndade Kaso, is that you leading us on that one?
Yes, it is.
Please go ahead, Ndade.
The proposal is that in light of the recent reconfiguration of cabinet, that the portfolio committee on human settlements and water and sanitation be split into two committees. The rules committee, rule 225 gives the speaker the power, acting with the concurrence of the rules committee, to establish a range of portfolio committees, assign a portfolio committee of government affairs to each committee, and determine a name for each committee. And these committees were determined at the start of this parliament, and the composition of committees is 11 members, and the breakdown is ANC 6, DA2, EFF 1, and other parties 2. And so without going through all these paragraphs, the proposal is that in order to give dedicated attention to these two portfolios, that Parliament must have a portfolio committee on water and sanitation and a portfolio committee on human settlements. And that's a proposal. Thank you, sir.
Honorable members, this looks like a consequential recommendation from the reconfiguration of government. Any comment on the proposal? Tasha?
Speaker, Tasha. Acting Speaker, I'd like to be short and sweet. I agree completely, and I hope that one day soon we will be coming and establishing a committee to do oversight in the presidency too. Thank you so much.
Thank you, ma'am.
Don't put that respect.
Okay.
My hand is up,
Yes, I'm
my hand
listening
is
to you,
up,
Honorable Chief Whip. Yeah.
Thank you very
Your
much.
hand was up, and you're also talking to your other fellow Chief Whip. So don't. You have your forum where you can talk to each other.
My fellow chief whip must not put other matters on the back door here.
Yes.
Acting Speaker, we fully support, as the ANC, we fully support that let's have two committees, Human Settlements Portfolio Committee, as well as Water and Sanitation Portfolio Committee. Thank you very much. We support this.
Okay, thank you. Any objection? Honorable Majorina, lower your hand. Thank you very much. If there's no opposition, we take it, it's agreed to. So the committee will be formed as is expected, as others have been before. Thank you very much, honorable members. That matter has been dealt with. Is there any earth-shattering matter that we must consider before we close this meeting?
Acting Speaker?
Yes, that is Tasso.
Just for minuting purposes, I just want, and I'm terribly sorry to do this. Is it my understanding that regarding the item before this one, that for next week we continue as things are, and in fact, as the Constitution provides, that person presiding must call for nomination at that meeting, and that we will not make a submission to the Chief Justice about next week. Was it your conclusion, say that for future elections we must make Chief Justice?
Yeah, let me ask this question first, so that I have a proper understanding of it. When I said so, I had in mind that there is a proposal already to engage the Chief Justice. Is there such a proposal on what would be an added issue?
There was a proposal, say, on this matter from the Chief Justice, but it was before some of the inputs were made today, especially that item 2 on Schedule 3 that says person presiding must call for nominations at that meeting, which is
Unfortunately, that one we can't vary. In other words, we cannot vary the requirements of the Constitution as is required of the Chief Justice, who will be in the chair. We can't vary that. So that has to proceed as is expected. So I don't know how any proposal then will meet that requirement. It may alter it in that in addition to the preparations, it may have to be done in advance. You help me think through that. Yeah, Mebrot, I see your hand is up, and Tasha Mazzoni, I see your hand is up as well.
Thank you, Acting Speaker. Acting Speaker, I believe that as the schedule was explained to us by Mr. Kaso, there is nothing prohibiting the Chief Justice as presiding to still call on the names as the Constitution suggests. Yes. But what we are trying to do here, as we always do when we do schedules to see who is going to call for division, who is going to what, we try
in similar manner
ourselves and the office so that people shouldn't stay there for a long time. And even though they will be called, but at least the office shall have prepared the documents. That is what we are saying here. And I think that should be considered. We are not going to float the rules and not say nominate. No, that will still happen, but we are prepared. Yeah. That's what we do under virtual meetings that we have all the time. We do that. We send names of people who will be asking questions and so on. That's my plea for the sake of this pandemic that we are in. Thank you.
Yes. Tasha?
Acting Speaker, I'd like to agree with Honourable Boroto. I think that perhaps what we should do is ask political parties who have an intention of providing a nomination to send the nomination through to Mr. Kaso. Mr. Kaso and his team can prepare the documents. However, that shouldn't limit anyone from the floor from being able to nominate. And if a nomination does come from the floor, then Mr. Kaso will have to adjust the papers. So the papers maybe, keep space for an added name if necessary. But of course, I do think that Mr. Kaso should consult the Chief Justice just to make sure that we are able to do that and able to do it legally. But I don't see any reason why we can't forewarn the NA table that we intend and who we intend to nominate. I think it will make things easier. But just to be on the safe side, let Mr. Castle chat to the Office of the Chief Justice to make sure that we aren't doing something that is detrimental and could cause us legal anxiety in the future.
That's the process of consulting the Chief Justice goes without saying. It is has to happen. And we did say that he has to approve any such provisions and so on. So let's do that in that Kaso. It's just a slight shift of the decisions we have agreed to. Let's do that.
We'll do so, sir. Thank you.
Thank you. Thank you very much. Honorable members, is there any other issue that we want to point out? In the absence of any other matter, the meeting is adjourned. Thank you very much.
Thank you, Acting Speaker. Thank you.
Thank you,
Honorable Acting Speaker.
Chief Whip.
You are available for what?
Recording stopped.
Mazoni say you are allowed to be available.
Chief Whip, I'm going to charge you for intimidating me.
This is why the sooner we get a speaker, the better. You won't charge me.
You hurried to close the gap so that I have no space to breathe.
Yes. Thank you very much. Thank you very much.
No, Sharp. Okay, take care.